everyone, and welcome to today's webinar hosted by Cipher. It's the October 2024 Employment Law Update with our friends at Shoosmiths. It's great to have you with us today. A quick introduction to who we are. So I'm Catherine, I'm Head of Content here at Cipher. I'll be your host and moderator. With me is my colleague Josh Phillips, who's one of our account development managers here at Cipher. He'll be telling us a little bit more about what we do in our products, just in case you haven't come across us before. And then I'm joined by the team from Shoosmiths, Stuart, Sian and Antonia. It's an absolute pleasure to have you guys back with us again for one of our semi-annual employment law updates. And I know we have absolutely loads to discuss today, so I'm not going to linger on the introductions. We're going to give you a really quick overview of who we are here at Cipher and what we do, just in case you haven't come across us before. And then I'm going to hand over to Stuart and Sian for the employment law update. There is the opportunity to ask questions throughout. Please use the chat functions to share those and send them in. There's a specific Q&A panel, and we will deal with those questions towards the end of our broadcast, or we may be able to answer some of them during the broadcast in text form in the Q&A panel. This webinar is being recorded, and the recording will be sent to you by email later today, so you can revisit any portions that you might want to look at again or share with a colleague later on. With that, I'm going to hand over to Josh for a quick introduction to who we are. Thanks, Josh.
Hi, guys. So yeah, as Catherine said, I'm Josh. I've been at Cipher now for about 5 years. So I thought I'd do a little bit of introduction in terms of who we are. So Cipher have been around since 1993. We've been supporting organisations with their people management needs in all that time. I always make the joke Cipher is as old as me because I was born in 1993 as well. And it's really sort of as an organisation, we've evolved over time, you know, primarily looking at HR. And as time has gone on, we've now sort of expanded out into the payroll industry, learning management, and most recently e-learning content. We've got about 650 UK clients, 1.5 million users globally, cloud-based solution. And as you'd expect with a cloud-based solution, we have all of the sort of necessary accreditations, things like ISO 27001, Cyber Essentials Plus as well. So if I just go in terms of what we do and all of our products that we sort of have within our portfolio are designed to support the end-to-end employee life cycle. So from recruitment and onboarding, talent engagement and well-being, management and productivity, and reward and pay. So that's just sort of giving you an insight in terms of work suite and something that we do also then promote is around integrations. Understanding organizations will have other solutions, incumbent solutions, and it's really important that you have the ability to farm that people data out into those solutions. So we have a pretty robust API and integration facility as well. And just sort of give you guys on the call today an insight to some of our customers. And you know, we have a solution that is configurable and can be bespoke to any organization's individual requirements. So for example, we've got the Met Office. Their system is going to look completely different to how Busy Bees. The same then, you know, it might apply to VW or any sort of organizations, for example, in the education sector and charity sector. But yeah, that's sort of my high level overview of who we are. If you have any questions at the end, feel free to drop them in and I'll hand over to the guys at Shoosmiths.
Thanks, Josh. Good morning, everyone. On behalf of Sian, Antonia and I, it is an absolute pleasure as ever to be delivering the employment webinar to you and on behalf of Cipher. For those of you who haven't attended one of these before, and by way of a quick introduction, my name is Stuart Lawrenson. I'm a partner here at Shoosmiths. I'm joined today by the quite simply brilliant Sian Hoare, legal director in my team, and the equally brilliant Antonia Blackwell, who is our resident professional supports lawyer, employment law geek guru, but she is a fountain of knowledge. I'm not, I think I say this every time, but I'm not quite sure where the time has gone since our last update. back in May. A lot has happened since then, and a lot has happened last week alone. The world has gone red, and it looks like things are going to get a lot busier for HR professionals and employment lawyers in the not too distant future if we were not already busy enough. I make no apology for the fact that on this occasion we didn't give you a choice of options as far as what we're going to cover today. We knew what was coming, so there could only be one main area of focus for us that Sian's going to cover. But the only other point I wanted to state again was that unfortunately you don't have the option to ask questions verbally, but please do use the platform that enables you to ask questions. We're probably going to deal with questions at the end, and if we don't have time, we are very, very tight for time today, but we'll think about what we can do by way of follow-up, but please do use that function. So in relation to what we're going to cover today, I'm going to start off with a really quick case law update, just dealing with 5 key cases that have been reported in the last 6 months. And Sian's then going to provide you with a legislation update and a look at what's coming down on the horizon, with a key focus on the employment bill. Without wishing to sound like I've got slopey shoulders, the employment law bill only landed last week, and we've only got until 12:15. So there is going to be a limit to what we can cover. There is going to be more, I promise. There's a great article on our website if you want to have a look at that. And Sian will give you some more details about other things that are coming down the track. But we're going to see what we can do. May try and break some records about what we can cover in an hour and 15. So I'm going to crack on with the case law update. So first case for me is the case of End Goal versus Touchstone Leeds. This is a rare case of religious discrimination, and it's also rare because the claimant was successful in pursuing a claim for direct discrimination. It's always useful to bring these cases to life by explaining to you what the facts are. So Mr. Engel was he applied for a job as a mental health support worker, and the respondent was a mental health support charity. And the purpose of the job was to support people with mental health problems when they were discharged from hospital, with lots of those individuals being in the LGBTQ community, and the job was conditional upon 2 job references. The claimant was actually a reverend, and he gave that job title at interview. He declared his faith in Christianity as part of that interview process, including his belief that marriage should be between men and women, and that sex and biology was immutable, so it was not possible to change sex or gender. What happened next was that one of those references that came back was not deemed to be sufficient, and the company did what a lot of companies do nowadays, and they did a bit of a Google search on the Reverend, and they found a series of articles about him, and some of them shown that he'd basically been thrown out of Sheffield University because of his views on homosexuality and on the LGBTQ community. And in response to that, they withdrew the offer. They were open about this, and they said that they thought that his views could impact upon his ability to do his job, noting the community that they support. He wrote back, it's fair to say he wasn't particularly happy. He threatened, basically brought up claims of discrimination, and he referred to a Court of Appeal decision that they hadn't found when they'd done their Google search, that basically showed that the university had changed their mind and allowed him to go back. So after reading that reply, they invited him to a second meeting, and the purpose of that meeting was to give him the opportunity to reassure them. But at that point, he didn't provide them with the reassurance they were looking for. They didn't reoffer him the role. And what happened next was that he brought claims of direct discrimination, indirect discrimination, and harassment on the basis that he hadn't been offered the job due to his religion and belief. Now, it was only the direct discrimination claim that was succeeded, and that was only in relation to the withdrawal of the offer after the first interview, when they realised or noticed the first article. They said that the decision not to offer him after the reconvened meeting wasn't an act of discrimination because he'd failed to provide them with the requisite reassurance. But the withdrawal of the offer originally was deemed to amount to direct discrimination, very rare for those cases to be upheld, because what the tribunal held was that they should have given him the opportunity to explain how basically his belief impacted and given the opportunity to put forward comments. So I suppose the learning point in relation to this case is that if you ever find out about beliefs, or in fact any protected characteristic, make sure you do have that conversation before any decisions are made that could potentially give rise to potential claims. Okay, so moving from religious discrimination to a case about disclosure, the case of Virgin Atlantic versus Loverseed. This was a case that involving a group of pilots who brought claims of unfair dismissal. There were 12 pilots in total. They were all made redundant during the COVID pandemic. Obviously, pilots were impacted massively as a result of the COVID pandemic. But I'm sure you're aware, whenever a company is going through a redundancy process, an employer has to ensure they go through a fair selection process before taking the decision to dismiss. And in this case, the pilots said that they were selected because simply because they were deemed to be what's called a middle band pilot. For the purposes of this morning, I haven't got time, or I don't need to go into any more detail other than the fact that Virgin had different categories of pilots, and they were just simply chosen because they were in that middle band. And as part of that tribunal proceedings, Virgin disclosed multiple versions of a spreadsheet containing financial information about the costs for each pilot, as well as information about the selection criteria that have been used. And the spreadsheets have been redacted in certain areas. And what the pilots argued was that they needed to see the unredacted versions of those spreadsheets because they thought that the unredacted content probably went to the heart of the issue, i.e. them proving whether or not the redundancy process was fair and whether or not the selection had been fair. And there was a preliminary hearing to determine this issue, quite a meaty preliminary hearing. And Virgin appealed the tribunal's decision because the tribunal made a finding that the unredacted documents should be disclosed to the pilots. Virgin was saying basically, no, they shouldn't. It contained business sensitive information, and they wanted only the unredacted documents to be available to the tribunal. And the EAT then considered this, and they sided both, or they agreed with both the tribunal and with the pilots. And they said that the redacted versions weren't good enough. The pilots did need to see the unredacted versions because the contents of those spreadsheets went to the heart of the issue, and it was essential for the pilots to understand them and ultimately the tribunal to understand them for the purposes of making a determination in relation to the unfair dismissal claims. And both, as just so that you're aware, both the Employment Tribunal and the EAT were able to have visibility of those documents in making that assessment. So the reason why we flag this is to always remember that when you're dealing with tribunal claims, that you comply with your duty of disclosure to the tribunal, and that it is a duty of disclosure to the tribunal. You don't just disclose documents that are relevant for your case. And in this case, the AT made some pretty negative comments about Virgin being very coy about the information that they'd provided, and they didn't consider them to be particularly transparent, and that's not a particularly good look. It's always good to be as transparent as possible, particularly in cases of redundancy. So be very careful about redactions, and if in doubt, make sure you take advice. Okay, nearly halfway through. Third case from me is the case of Orwin versus East Riding Yorkshire Council. And this case involved a claimant and the use of pronouns on his email sign-off. So in this case, Mr. Orwin was employed by the council as an IT project officer. He held gender critical beliefs, much like the first case I talked about. His belief was that sex is determined at birth, and you can't change your sex or gender after that. So what the council did in this situation, in this case, was that they introduced a policy, much like many employers up and down the country have done so, basically explaining that if employees wanted to change their sign-off, they could add pronouns to their email sign-offs. The policy that the council introduced, though, was not particularly detailed. It gave a couple of examples, but beyond that, all it did was basically refer the employees to some guidance on the internet so that they could get, I suppose, more of a flavour as to the sort of pronouns that could be used, and so that they could understand a little bit more about why they were doing what they were doing. Mr. O wasn't very happy with this policy, and he thought that it promoted a political ideology that conflicted with his beliefs. And he raised a complaint with the council, and essentially in protest he put to them that he would be changing his pronouns in his email if they didn't retract or change their position on the policy. So he basically said, look, if you don't do this, then that's what I'm going to do. And the pronouns that he said that he was going to use were not particularly usual pronouns. They're quite long-winded. He said that the pronouns that he was going to use was XY chromosome guy / adult human male. Not in accordance with the company's council's policy, as you can well imagine. And the council said it wasn't permitted. And when he added them to his sign-off, the council asked him on numerous occasions to remove them, and he didn't. He put in another complaint, and whilst his complaint was ongoing, he didn't change his sign-off. Once that complaint had been finished, he still didn't change his sign-off, and the council immediately told him that it wasn't acceptable and he needed again to remove it. They went through various further rounds, and ultimately the council decided to dismiss him on the grounds that he wasn't following a reasonable management instruction. He pursued a claim for unfair dismissal and discrimination on the grounds of religion and belief. So the first thing in these sort of cases is the employment tribunal has to make a determination about whether or not his belief was protected under the Equality Act, and they applied the now well-established test that was self-established within the case of Granger, which looks at what things the tribunal needs to decide when assessing a philosophical belief. So that's whether or not the philosophical belief is genuinely held, whether or not the belief is a genuine belief and not just an opinion, whether or not it is weighty and forms a substantial part of human life. It must attain a certain level of cogency and seriousness, and it must be worthy of respect in the democratic society and not conflict with other fundamental rights. And the employment tribunal made a pretty quick determination here, and they found in his favour. So what they then had to decide is whether or not ultimately the dismissal was unfair, but also, and crucially for these purposes, whether or not there was any form of discrimination here. And in these situations, then what the tribunal has to look at is basically the manifestation of the belief, and that comes into the tribunal's decision-making process. And what it found here was that it wasn't his belief that was impacting on the decision to dismiss him. It was how it manifested that belief. So it wasn't that he was taking issue with the policy because of his beliefs. It was more that he was protesting against the policy by using those pronouns for his email sign-off, and also the fact that he refused to take them down once he'd put them up. So it's a really, really subtle differential here. The tribunal did criticise the council's policy. They said it was pretty vague and they could have done a lot more to provide support, and they said that the council could have done a lot better in introducing the policy. But the tribunal found in his favour in relation to the decision to dismiss him, because they said that the decision to dismiss him was based on his failure to follow the reasonable management instruction, and the management instruction to take down those pronouns was fair and reasonable because Mr. O was protesting against the policy rather than just manifesting his belief personally. So really subtle nuance there about the difference of those two types, but again, an interesting case. Penultimate case for me is the Valhuma case, and it has provoked lots and lots of debate in Shoosmiths. It'll be interesting to see whether or not it provokes any reaction amongst the nearly 700 people who are online this morning. This revolves about an individual who was put at risk of redundancy and ultimately dismissed, but the case focuses around the selection process and the individual being put into a pool of one. It's a pretty common scenario. The claimant was a liaison support officer and he covered the northwest of England. He was one of a group of support officers for the employer, but he was the only one who worked from home and the others were all office based. The foundation suffered a reduction in work nationally, and therefore they had to reduce, or they had a reduced need for people to do work of a particular kind. And because he was the only person doing work from home, they decided just to put him at risk of redundancy rather than the entirety of those employees who are doing that work. And he was therefore placed within a selection pool of one. They consulted with him 3 times, had 3 separate consultation meetings, but ultimately his employment was terminated and he brought a claim of unfair dismissal. The tribunal deemed that his dismissal was fair, and it was quite correct that he should have been placed in a pool of one. He wasn't happy with that. He went off to the EAT, and the EAT actually allowed his appeal. And this is where it gets interesting, because the EAT said that there should have been more thorough consultation process undertaken, and they should have consulted with him before they finally decided on the pool and limiting the pool just to him alone. They should have allowed him to give feedback about whether or not his role was unique and whether or not it should have been considered in isolation. And for consultation to be meaningful in a case like this, it should have included consulting about the pool, because that could have impacted on the later redundancy process. So what the said is that what the foundation should have done is they were quite happy for him to have been provisionally put into a pool of one, but they should have invited him to then put forward his opinion as to that pool, sought his feedback, considers his feedback before finalising and confirming that decision and proceeding with the consultation process. And because the foundation basically didn't talk to him about this in any way, shape or form, it was found that ultimately the decision was unfair, albeit only on procedural grounds. I think this is a really interesting case, because this is something that we advise on a regular basis. We get lots of queries from clients on scenarios such as this. I think employers have historically, there's lots of case law there which confirm that employers generally have quite a lot of flexibility when it comes to determining pools, and pools of one are often seen as being, I suppose, the easiest type of redundancy to progress. But if you are facing redundancy situations like this, make sure you do address your mind to the pool and think about whether or not you need to consult about the redundancy pool as part of your consultation process, and as ever, make sure that is documented. Okay, looking at time. I'm on time, Sian. That's all good. Last one from me is the case involving another case involving the Royal Mail. I think they've had enough of litigation, but this is a last case about reasonable adjustments. So Mr. Cairns was a postie. He was in post. Hey, to get that, that's a good. I have to have one cheesy joke. But he was in post, excuse the pun, since 1990. He had an accident in 2016. He suffered an injury, and the injury was such that he was disabled for the purposes of the Equality Act. That wasn't ever disputed, and it meant that he could no longer carry out his normal postman duties. The Royal Mail obviously does an awful lot more than just delivering physically post to our doors. They have lots and lots of other roles that are available. But at this point, they didn't really have any vacancies available for him. But despite this, they did manage to basically create a bit of a role for him, and he moved to an internal job to keep him employed because he simply couldn't do his previous role. Unfortunately, that couldn't carry on indefinitely, and in 2018 the Royal Mail took the decision to dismiss him because of ill health. He brought claims of unfair dismissal, discrimination relating to his disability, and failure to make reasonable adjustments. So there's a couple of key facts here that I need to flag. So the first key fact is that at the same time as bringing his claim, he also appealed the decision to dismiss him. The second key fact was that at that time there'd been talks, you've probably seen it in the press, about the Royal Mail merging with another organisation. But at the point that he was dismissed, Royal Mail was saying, we don't know if this is actually going to go on ahead. This is very uncertain. The third point to flag is that had the merger gone ahead, there would have been lots more vacancies available for him. And the fourth key point is, at the point that he was appealing his decision, the merger was far more further progressed, and it was going to probably take place within a couple of weeks of the appeal process. So at the first instance, the Employment Tribunal, they found that it was fine for him to be dismissed on the basis that Royal Mail could not keep his job going indefinitely. He appealed that decision, and the EAT had to look at this, and they took into account obviously the timing of his appeal and what was then apparent from a merger perspective at the point of appeal. And the EAT found that because at the point the merger was going to take place, it was known that jobs would be created. What they should at that point have done is reinstated Mr. Cairns at this stage, given his job back, sat out the last few weeks until the merger had taken place, because at that point he would have found a permanent office-based role. So it's a really interesting case about the facts that need to be taken into account basically at the appeal stage. If there's new facts that have been taken into account, you now need to take that account. So it's important, because this case highlights, this is the last point I'm going to make, is the fact that I think we all know that the duty to make reasonable adjustments applies at all stage of the appeal, of the employment journey. We often talk about needing to make reasonable adjustments when you're recruiting employees, but this confirms that the duty to make reasonable adjustments applies right up to the 11th hour, including making reasonable adjustments during any appeal process. So there we go. It's 11:25. Sian, I said I'd be done by 11:25. Over to you. Thank you.
Thanks, Stuart. Good morning, everyone. So yeah, I think it's safe to say, whatever the weather out there, it's never a dull day, is it, as a HR professional or an employment lawyer. We kept on our toes with new case law, change in legislation, new government, even more new legislation, and then let's not forget the day job. So I think it's fair to say we've got a substantial amount of new legislation coming through at the moment. And as businesses, more than ever, we need to start trying to kind of plan ahead of some of these changes to reduce the disruption to your business when they do take effect. So in terms of what I'm hoping to cover today, apologies, I've just skipped a slide. We're going to look at some of the key changes that are being implemented or about to be implemented, but spend the majority of this part of the session on the Employment Rights Bill. So in terms of what I've got first on the slide there, it's the Code of Practice on Dismissal and Re-engagement. So as you all know, employers will sometimes need to change terms and conditions of employment. And if employees don't consent, then as a very last resort, an option available to employers is to consider dismissing employees on the grounds of some other substantial reason, and might seek to re-engage under new terms and conditions. And this is known as firing and rehiring. And you'll have seen the fire and rehire kind of controversy with the cruise operators in 2022 and 2023. And then more recently, Tesco's has hit the headlines when it lost its Supreme Court battle over fire and rehire plans. So this is very much a reaction on the government's reaction to those high profile cases. And our last government brought in an updated code of practice on the 18th of July, which you should be familiar with. But just flagging some of the points in this code, you should be engaging in meaningful consultation with trade union and employee representatives to try and find an agreed solution. You should always be revisiting business plans and taking reasonable steps to explore alternatives before going down this route, which I'm sure you would all do anyway and would need to do to establish a fair dismissal. You should not use the threat of dismissal to put undue pressure on employees to accept new terms. Question what a threat is, if that is the plan, but equally what is undue pressure, but just flagging that. And also you should only phase in changes that have been consulted on. And I think the main new bit here is just contacting ACAS before actually raising the prospect of dismissal and re-engagement. So make sure that you're familiar with that, and also noting that any unreasonable failure to follow the code can potentially result in an increase of award of up to 25% by a tribunal. Well, our new government has said this new code that's recently come in is not enough, and they're going to replace this code with a further strengthened code with some effective remedies, and will make dismissal unfair except where there's genuinely no alternative, such as due to financial difficulties. But clarification on what these exemptions will be absolutely critical. But please make sure that following these reforms closely if you are planning any reorganisations in your business or contractual variation in the near future. Another couple of flags here in terms of what's recently come in. Some small changes to our GP legislation, but welcome changes. So you'll be familiar that previously micro employers, so those that employed less than 10 employees, so rarely came into play, did not need to elect reps for the purposes of informing and consulting under GP. So it had a very limited application. The amendments to our GP legislation sees the requirement to elect reps removed for employers with less than 50 employees, so a lot more companies will fall within that, and for employers of any size for transfers involving less than 10 employees. And that's taken effect since the 1st of July. And so that's a really useful tweak, because quite often it might just be a small part of your business or a service provision change where there are less than 10 employees transferring. And the need to elect reps can obviously cause some delay to the process if you don't already have elected reps. And quite often it is better and more personable to speak to individuals direct when you've got numbers of this size. Just also flagging, appreciate it might not be relevant to most of you, but from the 1st of October, we've got this new legislation, the Employment Allocation of Tips Act, which introduces a requirement for employers to pass on all tips and service charges to workers without deductions. And then there's also an accompanying code of practice. Right. My next slide is one that absolutely should be on your radar, and you need to be reviewing what you've got in place. So on the 26th of October, so that's next week, there are going to be new sections to our Equality Act, which are introduced by this Workers' Protection Amendment of Equality Act. Employers are going to have a positive duty to take reasonable steps to prevent sexual harassment. Not sure what's going on there. Apologies. To prevent sexual harassment of their employees in the workplace. Can we all see the slides? They seem to have jumped off from my end there.
Yeah, they've dropped off. Let me try to figure out why this is not. I'm not quite sure why this is not working. Sorry, everyone.
That's all right. I'll carry on speaking, but
okay.
Stuart, maybe it's possible for you to kind of.
They've come back. What slide number do you need, Sian?
We were on
Tips.
Slide 21.
21. There you go.
That's it. So yes, just looking there at this new preventative duty that's been introduced to improve workplace cultures by requiring employers to anticipate how sexual harassment might happen in the workplace and take reasonable steps to prevent it from happening. And just as a quick recap, the Equality Act defines sexual harassment as unwanted conduct of a sexual nature, which is the purpose or effect of violating someone's dignity or creating an intimidating, hostile, degrading or humiliating or offensive environment for them. So compensation for discrimination complaints are uncapped, but employment tribunals will be able to award an uplift of up to 25% to an employee's discrimination compensation where they breach this duty. The law doesn't actually define what is reasonable or list any specific steps an employer must take, but we know that it's not going to be enough anymore just to simply have policies, provide training, and have a zero tolerance approach to sexual harassment. We do have some more guidance from the European Human Rights Commission, which they published at the end of September. And this technical guidance sets out this new 8-step preventative guide on how to prevent sexual harassment. We're going in a minute, we'll go on to the next slide, which sets out in some more detail these 8 steps. But I just also wanted to flag that for the government, this new legislation is not enough. And the Employment Rights Bill is going to seek to further strengthen this duty to prevent sexual harassment by requiring employers to take all reasonable steps rather than just reasonable steps. So we'll see from the regulation what that standard is expected to be. But the bill is also introducing this liability on employers for third-party harassment of their staff as well. So just moving on to this 8-step guide on preventing sexual harassment at work. It's like the slides dropped off again there. I'm not sure if they have, but in terms of this 8-step guide, it really is a must read. And it makes it clear the steps are not an exhaustive list, but implementing them should help an employer take positive action to assess risk and prevent and deal with sexual harassment in the workplace. So in terms of these 8 steps, it's developing an effective anti-harassment policy, and it sets out what should be covered off in the policy in this European Human Rights 8-step guide. So do please have a look at it. It sets out the fact that you should engage with staff, and it gives ideas on how you can go about doing this and what workers should be aware of. Equally, it sets out that you should assess and take steps to reduce workplace risk. In terms of how you go about assessing and reducing workplace risk, you need to carry out a risk assessment. And the guidance again sets out helpful pointers on what factors you should be considering in identifying those risk areas. You should be also considering using a reporting system that allows workers to raise an issue either anonymously or in name, and keeping centralised confidential records of all concerns raised, formal and informal. And this enables trends to be identified. The 8-step guide also sets out that workers, including managers and senior staff, should be trained on what sexual harassment is, and what to do if you witness or experience sexual harassment, and how to handle complaints. And regular training should be provided, but not just regular training. You should review that training to make sure that it is actually effective. Next in the 8-step guide is knowing what to do when a harassment complaint is made. You need to act immediately to resolve it, respecting confidentiality and protecting from being victimised. Next is dealing with third-party harassment. Always need to treat it seriously, and just as seriously as any harassment from an employee within your organisation, and assessing risk areas and taking steps to prevent it. And finally, regularly monitoring and evaluating all of those steps to make sure that they remain effective. So please do look at that EHRC guidance. It sets out really important steps there that you should be familiar with. And let's try and eradicate sexual harassment by not just making this a tick box exercise. We really need to empower our leaders as well to make sure that they're on board and putting all of these steps in place. I think in terms of one takeaway as a HR professional that we quite often come across is that if the victim wants the complaint to be dealt with informally, they just want the behaviour to stop. As HR professionals, appreciating that you want to respect their confidentiality, it always has to be the case that you explain to them why that isn't possible and how serious it is, and the fact that you need to investigate it and deal with it in accordance with your procedures, acting promptly. Can we see the slides at the moment? It looks from my screen as if they've dropped off again.
Sian, it's Stuart. I can see them. I don't know about other delegates.
Okay.
Catherine can reply.
Perfect. Right, just moving on to what I'm sure you've all been waiting for, which is the Employment Rights Bill. I don't know about you, but last Thursday seems to be a lifetime ago now. But the 10th of August was really a historic date for employment lawyers, HR professionals, with the introduction of the Employment Rights Bill. It makes significant changes to our UK employment law. And although the bill is 158 pages long, it seeks to make 28 separate changes. And is typical with employment legislation. There will be further policies in the bill. There will be the need for further regulations, some codes of practice after royal assent. So the government plans to consult further on these changes in 2025, meaning actually the majority of these reforms aren't going to take effect any earlier than 2026 and more likely the autumn of 2026 onwards. So the purpose of this bill is to modernise employment rights, grow the economy, raise living standards across the country and create opportunities for all. It will tackle low pay, poor working conditions, poor job security, all of which is perceived to be holding our economy back. The subject matter is vast. Just to flag that we will be running a webinar on just the Employment Law Bill on the 7th of November, and a link will be shared in the Q&A to this session if you would like to sign up. But just to go through today with you the key headlines. And the first one on the list there is the day one rights for unfair dismissal. And this is one of the most significant changes. As you'll know, currently employees need to have worked for a company for 2 years to qualify for unfair dismissal protection. And this proposed change will mean that you qualify for unfair dismissal rights from the first day of employment. And most companies will use this initial 2-year period to assess an employee and their suitability for their role. And subject to there being no discrimination or no automatic unfair dismissal claim, it'd be commonplace for employers to go through a short service dismissal process that doesn't follow the ACAS code and going through all the level of warnings if the employee isn't working out before they accrue their unfair dismissal rights. But day one unfair dismissal rights will circumvent this. Having said that, the bill does allow for regulations to be made relaxing the requirement for a fair dismissal during an initial period of employment in order to allow employers to carry out a proper assessment on the employee's suitability for the role. So in terms of what this initial period of employment is, so what we'll refer to as a probation period, what is this probationary period going to look like, and to what degree can you go through a lighter touch process during this time? This is all going to be subject to further consultation. I think it's likely that this lighter touch process will look much like what we would recommend as a short service dismissal process now. And I say recommend, we would recommend that even if an employee's got less than 2 years service, you do invite them to a meeting, hold a meeting, determine an outcome, really to evidence the real reason for dismissal and mitigate against the risk of claims. Although at the moment, short service dismissal process isn't a statutory process as such, it's just recommended. The qualifying period for unfair dismissal claims, I think a lot of you have been on this journey with us. It has changed over the decades, starting as 2 years, then went to 1 year, then 2012, it went back up to 2 years. At the same time, they introduced the tribunal fees. So the data that we have from that period is a bit skewed, but 12, sorry, when it went to 2 years, yes, we did see a decrease in tribunal claims, but I think that was probably more so to do with the introduction of the tribunal fees, which has since been abolished. So I do think we are likely to see some increase in tribunal claims. But you can hope that equally it might simplify some tribunal claims where employees have thrown in discrimination claims because they didn't qualify for the unfair dismissal complaint. But equally, we know employees do still kind of tend to just throw in the kitchen sink and do throw in discrimination complaints just because of the perceived strength of the negotiating position, where you don't need any qualifying length of service and compensation claims are uncapped. But we can hope that it might simplify some tribunal claims. Referencing that we don't know what this probationary period is going to be, the government has suggested that it might be 9 months. And to be honest, in my view, whether the probationary period is 6 months, 9 months, or unfair dismissal rights being 1 year, which is what it did ultimately used to be, probably there's not much of a difference between that timescale in trying to determine the suitability of an individual for their role. I don't think there's enough time either way, really, for an individual to demonstrate their worth or what they can add or achieve real objectives during that period. And I think, therefore, the unfortunate unintended consequence of government is that employers are probably going to be making decisions on employees' continued employment before they should be, and whether they make the right decision or not, or take a cautious approach. I think further negative unintended consequences are that employers might be reluctant to take on as many new recruits, or they might be tempted to recruit from pools that they perceive as being lower risk, or where management already know those individuals from past connections. So this could have a real negative impact on diversity initiatives. In terms of how businesses can prepare for this change, you will need to look at your probationary periods in your contracts of employment when we know more about what this statutory period is likely to be, and amend clauses to provide us with maximum flexibility. I think a positive change that we're going to also see is much more investment into our recruitment processes and making sure that we get it right. And that must be good for employees and employers regardless, because there's so much time, isn't there, spent on the onboarding and training of employees. So have a think about how you're going to get your recruitment processes better. Do some analysis there. Are there learning points that you can glean from other parts of the business where they've got high performance and low attrition rates? But certainly some analysis will need to be done there. And then I think as well, there's going to be a lot more work, isn't there, in process for HR to be on top of, but also making sure your line managers are well equipped at earlier stages in knowing how to comply with a fair process. So you will need to consider upskilling your line managers so they can be effective, efficient and proactive in managing their direct reports, making sure that you treat everybody the same. And, this may well bring about improved performance accords, so we don't just let certain issues drift. Next on this slide is just flagging changes in relation to fire and rehire that the employment bill also promises, which I've already covered, so won't go over again. Just flagging in relation to flexible working, we've already seen changes in April this year on the day one rights, which will be retained. But what the government's also proposing to do under this bill is add to the reasons that you can refuse the requests. So further regulations will be needed on this. Then in terms of 0-hour contracts, now that takes up a significant proportion of this new employment rights bill. So with all of this, there'll be new subject sections added to our Employment Rights Act. And this new provision will require employers to offer within a certain timescale. It's all quite prescriptive, but equally they haven't told us what these timescales and defined periods are yet. But employers will need to offer 0-hour workers and workers with a low which have a low number of guaranteed hours. You can't circumvent this by just giving your workers a low number of guaranteed hours. This will apply to those workers as well, who regularly work more than those hours. So this is going to capture 0-hour workers and those that are on low number of guaranteed hours that regularly work more than those hours. And there's going to be this requirement to offer those individuals a set minimum number of hours per week on set days and times after they've worked a qualifying period, and it will be based on a reference period, which looks like it might be 12 weeks, but again, that's not been set yet. And it should, in terms of what you're offering them, reflect the pattern that they had been essentially doing. And then if actually it turns out they're regularly working more hours than that, then there'll be subsequent reference review periods that need to be undertaken. So in terms of what constitute low hours in the first place, the government needs to consult further on that. So we await that detail. 0-hour contracts, as we know, are used a lot in the hospitality, tourism, farming industry, where you've got fluctuating demands and seasonal needs. And 0-hour contracts provide the flexibility. So I think, these types of employers who rely heavily on 0-hour workers are going to need to revisit their employment models going forwards and how they engage staff. And or get very familiar with these new regulations when they come in. So I think, it will certainly be easier for employers to consider at the outset, if you can guarantee a number of hours which exceeds this low number of hours under a permanent contract, then you may as well just do that. I think it's also unfortunately likely that some employers are going to consider just using a particular pool of workers that they know are reliable, and just giving them those guaranteed hours. Obviously, you can't do it in any discriminatory way. But again, that's not going to be very positive for diversity initiatives. I think undoubtedly a lot of employers are going to think, right, can I use a fixed term contract instead? There are various anti-avoidance provisions that are set out in the bill. And whilst you can use fixed term contracts, it's only where it's reasonable and justified. And you'll need to demonstrate that it's either for a specific task, occurrence of a particular event, or there's a temporary need, which is the most likely scenario to apply. So just to flag that whilst an offer will need to be made within a certain period, it will be within the gift of the employee to reject it if actually they're happy to continue on those arrangements. But yeah, I think, these proposals do appear to spell the end of 0-hour contracts unless the employee indicates they're happy to keep that flexibility. Employees will be able to bring claims to the Employment Tribunal for failure to comply with these regulations. Compensation will be just and equitable, but they haven't set what the maximum award is going to be yet. And the bill also further goes to note that workers will need to be provided with reasonable notice of change in shifts, with proportionate compensation available for cancelled or shortened shifts, providing them with more predictable income and better working conditions. So yeah, these provisions are going to replace what the Workers' Predictable Terms and Conditions Act, which our old government had intended to bring into force, but that won't be necessary now. So next on that list is collective redundancy. So as most of you will be familiar, where an employer is proposing to dismiss as redundant 20 or more employees at any one establishment within a period of 90 days or less, collective consultation obligations are triggered. And with that, you've got an obligation to inform and consult with your elected employee representatives. There are prescriptive timings, requirement to issue the HR1 form to the DBIS. And a failure to do so can have criminal sanctions in terms of failing to issue that HR1 form, and other claims for failure to inform and consult with a protective award of up to 90 days pay, and potential unfair dismissal claims if you get it wrong. So it can be expensive not to recognise when collective consultation applies. And also noting actually the definition of what constitutes a dismissal under this legislation is much wider than redundancies. It does include where you are going to be potentially dismissing individuals where they don't agree to variations in contracts, or where there's a potential constructive dismissal claim. So it is important to be mindful of all of that. So at the moment, not the get around, but quite often it would have been the case that you didn't have 20 or more employees at one establishment, so it didn't trigger the collective consultation, but not that heavily publicised, but a very significant change. The Employment Rights Bill will take away this one establishment for the trigger. So inevitably, there are going to be lots more collective consultation obligations triggered as a result of the removal of this word, where you've got multi-site businesses. It is possible that some employers might look at changing their group structure to separate out and have new legal entities to try and get round this. I think that would be very onerous. I think more likely employers are going to have to, with multiple sites, keep in communicate, make sure that there's some kind of centralised database to log redundancies across locations to ensure that it's not falling foul of its collective consultation obligations. Next on the list are these day one rights for sick pay and in respect of parental and paternity leave. So with sick pay, the Employment Rights Bill is saying that we're not going to have this lower earnings threshold anymore. That's not necessary. And you're not also going to have to wait 3 days before you are entitled to statutory sick pay. It will become a day one right. I don't think this is going to bring about a significant change. Statutory sick pay is £116.75 a week and £23 a day. So I don't think it's going to encourage more sickness as such, and it's probably not going to have a huge financial implication on employers. You will need to make sure your payroll is alive to this change when it does come into force, so that you can pay employees correctly. And then, yeah, just noting that the right to parental leave and paternity leave will also be one right, and also the ability to take paternity leave following in a period of shared parental leave will be introduced, along with a statutory right to a week's bereavement leave. So these will just be points that you need to update your policies with when it comes in. Next on the list there is the just flagging maternity dismissals and the sexual harassment piece, which we've already covered. But the bill is also going to allow for more regulations to make it unlawful to dismiss a woman during or after a protected period, which is likely to be 6 months, of pregnancy, maternity, adoption, or shared parental leave, other than for reasons of redundancy. And then also noting that large employers are going to be required to create action plans on addressing gender pay gap, and supporting employees through menopause, and regulations to be made to also include outsourced workers in gender pay gap reports. There's going to be the introduction of what's referred to on the slide there as this Fair Work Agency, this single enforcement body, which will be introduced to look to basically investigate breaches of employment law, impose penalties, and support workers in disputes with their employees. So it'll be interesting to see the interaction with ACAS and our tribunal system as well. And then also this promise to for trade unions to basically not have such, as the government sees it, unnecessary restrictions placed on them. They're looking to introduce a sector-based collective bargaining agreement for the care sector. They're looking to also update trade union legislation to take away restrictions and make it easier to get statutory recognition. They've also noted that they're removing this legislation that came in just last year on this minimum service level, and also banning or prohibiting agency workers from being able to cover the duties normally performed by these workers. So there's a lot going on. Like I noted, there are 28 separate changes. We've flagged the key ones in this slide here. I think there's a lot to digest. There's a lot more stages before this legislation receives royal assent, and then obviously there'll be further consultation before we get more regulations. So nothing's going to happen overnight and unlikely to happen for a couple of years. So we've got some time to think more about it and prepare for these very significant changes. So just wanted to briefly look at what's on the horizon. We've got just a flag here in terms of the national minimum wage. Labour has announced its plans to make sure that the Low Pay Commission also takes into account both the cost of living and inflation when it reviews the national living wage and minimum wage. And also Labour's plans to actually remove the age band for national minimum wage for adult workers, so that everybody gets the pay the same irrespective of age there. And then with the Employment Rights Bill, we also got this next steps documents to make work pay, and there's some kind of interesting proposals in there that you'll have heard in the press already, but they haven't quite got round to yet, but still very much the intention to introduce further regulations on a new right to switch off, which would be interesting. Also making it mandatory for large employers to report their ethnicity and disability pay gap, extending equal pay cases to include race and disability as well. They're looking to move towards a single status of worker, so you'll either be employed or self-employed, which would certainly, well, reduce our case law and be very interesting and arguably expensive. And then there are plans to review the parental leave and carers leave system as well. So all of this will need further consultation before changes are brought into effect. Just then further flagging as, dare I say it, Christmas approaches and the new year, but just to make sure that it is on your radar. You'll have seen for the last couple of years the digitalisation of our UK immigration system. But just to flag here that much like the US, having the ESTA that's required before you get to the US borders, the UK has a similar thing that's been in place for your visa nationals for some time already now, but but coming in from the 8th of January, this will also apply to non-European non-visa nationals. So they'll need to get what we refer to as this electronic travel authorization to come to the UK. And then all European nationals will be required to get this ETA from the 2nd of April next year. So there'll be an app that you apply through. There'll be some questions gleaning various biometrics and suitability questions. You're meant to get it back within 3 working days, but certainly close to when these changes have been implemented, you should make sure employees are doing this further in advance, just to allow for any delays. The other point to flag is that from the 31st of December this year, biometric residence permits and other physical immigration documents will no longer be valid evidence to prove somebody's UK status when travelling to the UK. So this has been in the pipeline for some time, and many employees will already have their digital account with the UK VI. But if they don't, make sure that they do if they're looking to travel around Christmas time, because the last thing they'll want is to turn up after their Christmas break back to the border, and the UK VI might take a very hard line. And if they don't have this digital account, then they might be refused entry back into the country. So make sure that your employees are aware of this. Furthermore, since April 2022, it's been the case that you need to use the digital right to work checks for your biometric resident permit holders as well. But it's certainly going to be the case now for basically anyone that's not British or Irish, that you need to use the digital online right to work part of the website to check somebody's right to work in the UK. So this is going to be digital now for everybody that isn't British or Irish. For those individuals, you'll still be able to use their passports to evidence their right to work. So that was and is an absolute bumper edition. There is so much going on. Hopefully you've got the key takeaways there of what's coming down the track, and I think we've got about 10 minutes now for some questions.
That's right.
Tonia's coming back. Great.
Yes. Sorry, it took a while. So I've been busy trying to answer as many as I can as we've gone along, because we've had loads of questions come in, and I knew we wouldn't get to discuss them all. But I've got a few I thought that we could talk to. So an interesting one that's come in, which is, when will all of these day one rights come into force? Isn't that the magic question on all of this? So I think that the Employment Rights Bill at the moment is going through Parliament. So it has to pass through the House of Commons and the House of Lords, and only once it's finalised and agreed by both houses would it get royal assent and come into force. But even after that, the government has said it is likely there will be further regulations, codes of practice, and they will consult about those things. So for things like the removal of the qualifying period for bereavement leave or parental leave or paternity leave, I suspect those regulations will be fairly quick to make, because they're not particularly controversial. So they may follow quite soon after the bill gets royal assent. For the unfair dismissal rights, the government have committed to saying that those reforms will not take effect before autumn 2026. So in effect, we've got a 2-year lead in to that. So it depends a bit on the day one right, but certainly I think you've got some comfort on the unfair dismissal. So we had a couple of questions around probationary periods. I wonder, Sian, I might pose these to you. So I think you might have touched on this a little bit when you were talking, but if a current probationary period in a contract is for 6 months, but what the government decide to do is to effectively bring in a 9-month statutory probationary period, would employers need to change their contracts? My view is that probably makes sense to do that, so to increase. Would you agree?
Yeah, I think you may as well try and utilize the legislation to its full and have that, so yeah, certainly for new starters, I would recommend reflecting whatever the government introduces as that statutory probation period.
Yeah.
we've had some very keen clients even before last week's announcements sending over their contracts and asking for their probationary periods to be reviewed, and obviously we're more than happy to do so, but in reality the devil's going to be in the detail. But yeah, I think alignment with the statutory position, everything's got, you know, as and when we've got the detail, that will be the time of reviewing probationary practices aligned with whatever the new world of unfair dismissal is going forward.
Yeah. I guess another option could be to have 6 months with, you know, a view to extend it, but make sure that it's, you know, for another 3 months, if you feel that would be fairer to employees. But again, you know, you'd still be able to then utilise the full 9 months if that is what it is.
Yeah, and that would, of course, that's only a change for contracts going forwards, because presumably current staff are likely to be through their probationary periods, although I guess you might need to think about any that cross over when we know when this actually comes into force. And we had another question around, should probationary periods be specific to seniority? And I mean, again, it will be interesting to see how this is dealt with, because you know, a one size fits all isn't always the best approach, but again, we don't really know what the government is intending in relation to probationary periods, and if there is a set period for an employee, then that's going to apply regardless of seniority. So I think it's a bit of a watch this space on that. I don't know whether.
Yeah, I think it'd be a bit like with notice periods. Obviously, at the moment under a contract, you've got you know, an entitlement to notice is the greater of your statutory period or your contractual notice period. So again, this is going to sound like we've got slopey shoulders, but it's that the devil is going to be in the detail, and it may be that the default position is that we're employers are always going to have the benefit of the 9-month period if that's where it lands, irrespective of what the contract says. Sian, I don't know if you got anything.
Yeah, may well be the case, isn't it? That still sits behind it regardless of the contract.
Yeah. And then I had there was an interesting question around enhancing sick pay. So there is an organisation that enhances their sick pay, but does it once somebody is through their probationary period? Would they have to enhance from day one? I don't think they would, because it's the Employment Rights Bill only talks about statutory sick pay, and obviously your enhanced position is purely contractual, so you're able to put whatever terms you want on that contractual sick pay, as long as employers are getting their statutory sick pay from day one. And then I think we've probably got time for one more, and I thought it would be useful actually to go back and pick up on the sexual harassment changes that are coming in from the end of October, so the end of this month. And we had a question asked around giving some guidance on the sorts of things to be considered when undertaking a risk assessment. And I mean, this is a massive question that we could probably talk about for an hour on its own. But I guess the thing is to try, it's going to be very specific, I think, to individual businesses. And it will be a case of looking at your business and what you do and the nature of the work that's carried out, and trying to think about where sexual harassment might occur. And I do think, Sian, you mentioned the 8 steps and the technical guidance that the EHRC's put out, and actually it is quite helpful, and there are lots of examples within it that might help to give a structure. And talking about things like, is the loan working? Are employees expected to go out to client sites on their own? Will you have customers or suppliers coming into your business and interacting? What, you know, structures are in place? Is there potential for kind of you know, peer pressure or anything like that? So but it is very unique to each business. I don't know whether you've got any other thoughts, Sian or Stuart, on that.
I mean, a good starting point is the EHRC guidance, which does have a list of factors that you can consider, noting that it's not exhaustive. But yeah, just trying to kind of work out where the weak points in your business might be, look back at past data and where these issues, you know, have arisen. But yeah, I think there won't be a one size fits all, unfortunately, with these risk assessments, but they will ultimately develop and various, hopeful example templates that, you know, in time we can share.
Yeah. I mean, the other thing I think the guidance suggests, or the code suggests, is carrying out a staff survey and asking people, you know, what their experience is and where they think the potential risks lie, and that can be a really good starting point if you don't know what, you know, where to start with your risk assessment.
Yeah.
Cool. Thank you. So I think we have hit 12:15.
Yes, we have unfortunately hit 12:15, which is our time limit, and we don't want to leave you anyone on the call longer, because I know you will almost certainly have other things to do. So thank you, Stuart, Sian, Antonia, for such a thorough review of all that case law and all those changes coming in the Employment Rights Bill. Thank you, Josh. You're here somewhere for running us through Cipher at the beginning. Appreciate you doing that. We really hope you've enjoyed today's webinar and that you found lots of value from it. If you want to stay up to date with what Cipher's doing, you can follow us on LinkedIn, and the little button's going to come up on the screen. You can find us on there, and that's where we share lots of stuff about our events. If you want more information about any of our products or solutions, you can opt in using the exit form at the end of this broadcast. If you'd want more information from the Shoosmiths team, you can opt in using that function there. And if you wanted to join Shoosmiths Employment Rights Bill specific webinar on November the 7th, you can find that link through their website, or it's in the public chat section of this webinar now. Otherwise, please take 5 minutes just to share some feedback in the exit survey about this webinar. We really do value your input, and that helps us improve for future sessions. So thanks everyone for joining us. That was a very long wrap up, and we hope you have a great rest of your day. Take care. Bye.
Thanks. Bye.
Thanks, guys. I think that was really good.
Oh, the slide thing really.
I'm sorry, Sian, that probably really threw you, and I don't know